right. All right. Thank you, everyone, for joining today's webinar. My name is John Takayama. I am Operations Manager here at the Alameda County Housing Provider Resource Center. And today, for our webinar, we have Mediation Service, and our guest speaker is Mae Villanueva for Rental Mediation Services.
Hello, good afternoon.
Before we get started, there's a little disclaimer I have to go through. The information you're about to hear is for general information purposes only, and it's not intended to be legal advice. Please keep in mind that every situation is unique, and the laws, rules, and regulations may have changed before, during, or after this webinar. Before acting, please be sure to obtain tax or legal advice from a licensed professional. The opinions and viewpoints expressed during this webinar are those of the presenters and do not necessarily reflect those opinions of ACHPRC or its members. Some upcoming events I want to let everyone know. We are able to get everyone free access to the Rental Income and Asset Protection Summit. That is sponsored through our affiliate organization, East Bay Rental Housing Association. That is tomorrow, July 17th from 2 to 3:30 p.m. You don't have to be a member. Tickets are normally $40. However, anyone that is attending through this webinar and accesses the achprc.org website can get the promo code that allows you to get that $40 ticket for free. Our next event is a housing provider workshop that's going to be at the Castro Valley Library. That's Wednesday, July 23rd from 5 p.m. to 7 p.m. Also, we do have a pop-up tent in front of the Hayward Hall of Justice. That's going to be on Wednesdays from 8:30 a.m. to 12 noon. That is right outside the courthouse in Hayward. All right. The Alameda County Housing Provider Resource Center is a proud sponsor of the EBRA 360 Trade Expo. That's going to be on Saturday, September 27th from 9 a.m. to 3 p.m. And that will be at the Rotunda Building in Oakland, California. This is actually the largest housing provider, landlord, rental housing provider trade show in all the East Bay. It's the biggest one of the year. We will be attending, and we hope to see you there as well. Right. With that, let's see, 1 second. And we're going to queue up Mae Villanueva. Thank you, Mae, so much for joining us today and helping us to host this webinar.
Good to be here. Thanks for having me.
Started. All right. Take it away, Mae.
Hi, so again, my name is Mae Villanueva. I'm with Rental Mediation Services. I am the program director and also a mediator. And I thank you for having me here. I have a lot of great information to share with everyone today, and I hope that you will benefit from this webinar. So we have a lot to cover, and so let's move forward. Next slide, please. So a little bit about Rental Mediation Services. We are a new program that is funded by Alameda County Housing Development, and they approached Center for Community Dispute Settlement, which is a nonprofit organization that provides mediation to the Alameda County people, and they have been around since 1995, and they started off in Livermore. Because they've done such a great job in going into the courts and helping people in courts to resolve their disputes through mediation. They were awarded this grant to start Rental Mediation Services to provide free mediation to folks in the unincorporated Alameda County. And that could be housing providers and renters that live in Castro Valley, Cherryland, Sunol. There's several of them. Let's see, Fairview, Castlewood, Ashland, San Lorenzo, and Hillcrest Knolls. So if I left anything out, let me know. But those are the communities that we're providing free mediation services to. CCDS offers low-cost mediation for other types of disputes. So you can always go to them if you need any mediation for other services. Next slide, please. So before I move on to talking about what mediation is, I just kind of want to tell a little story about how this all came about in the unincorporated area. In the unincorporated areas of Alameda County, tensions between landlords and tenants had been building for years. Rent increases, maintenance issues, and lack of communication were fueling disputes, and many of these conflicts would end up in court. And it would drain time, money, and the community trust between housing providers and renters. So Alameda County Board of Supervisors saw this pattern, and they wanted to address the housing challenges and not just about rents and repairs, but they were also about communication breakdowns that would ultimately lead to going to court and filing lawsuits. So the board recognized this and recognized that this is a critical housing problem, and it affected public health, safety, and stability. So in December 14, 2024, they passed Alameda County Ordinance Chapter 3.68. It's a law with a simple but powerful idea that if landlords and tenants housing providers and renters, we're moving towards saying, using housing providers and renters now, which is awesome. But if I say landlords and tenants, pardon me. So they wanted a chance for housing providers and renters to have a formal way to talk with a mediator that would help them solve their problems without going to court. So it's basically called early mediation and intervention, really. The ordinance was built on 4 core beliefs, which is disputes can be resolved through dialogue, peaceful landlord, I said again, peaceful housing provider and renter relationships benefit the whole community. Voluntary resolution is better than litigation. And sometimes mediation needs to be mandatory to work. So we can cover that issue later, the mandatory part. But for the most part, the intention is to resolve issues before going to court. So with that, I would like to talk about what mediation is. With the show of hands, or if you want to just raise your hands virtually, who here knows what mediation is? Okay. Oh, John knows. Thank you. And I myself knows, of course. But so mediation is a structured, voluntary, and most importantly, confidential process, which involves a mediator, a neutral person who has no stake in the game, no skin in the game. And their job is only to help the parties resolve disputes. We facilitate communications between the parties. We facilitate negotiations within the parties so that the parties can resolve their conflict and come up with creative ideas of their own to resolve the situation. Our role is to support productive dialogue and help the parties explore mutually acceptable solutions. We do not make decisions or impose outcomes. We empower parties to speak to each other and to tell their stories in a safe environment. When successful, the outcome is a written agreement, and it's also enforceable in court. And so they have teeth, and then these agreements can be legally binding and enforceable in court. And usually that's what happens, and very rarely where there is a breach in the agreement. For the most part, parties are happy with their agreement and they follow through with what they agreed on. Next slide, please. So again, the role of a mediator gives guidance on how to prepare for mediation. We will tell you everything from start to finish on how to go through this process. We listen to each party. We take the time to hear exactly what's going on. We don't take sides. We don't side just with the renter. We don't side with just the housing provider. we listen to what the story is, and then we help you move forward. We also steer parties towards resolution. Sometimes parties want to talk and talk and talk and talk about what the dispute is. They want to focus on that, but we're trained to help you move forward to finding a solution. We don't give legal advice. Again, that's for the attorneys to do. We always will say, hey, this sounds like something that you might want to ask your attorney. If it's a legal question, we will always offer that all throughout the process of mediation. And of course, we don't tell parties what to do. If parties say, look, we've tried all we can, and there's no way we can resolve this, then the mediator will say, okay, let's conclude mediation. And then parties are more than welcome to move forward to their next steps. Next slide, please. Does anybody have any questions thus far? I know I'm kind of moving fast on this. I want you to have an opportunity to process all this information. So I'm going to pause for a little bit just to see if anybody wants to ask any questions.
Yes, this is an open forum. This webinar has been set up as an open forum. So if anyone has a question to ask about, especially about a slide that we're on, please unmute yourself and go ahead and ask the question. Does anyone have any questions so far?
No? Okay, maybe later. Okay, so the mediation process under 3.68. Basically, 3.68, the chapter 3.68 says that mediation has to occur before housing providers or tenants move forward to courts. So it is an ordinance, which means it is something that's required. So the mediation under 3.68 process is a renter or the housing provider can request mediation. And I will talk a little bit more about what situations you can request. And then the mediation provider will do the intake. Then we will, and that would be Rental Mediation Services. Then Rental Mediation Services, or RMS, will provide a mediator to the parties. The mediator will usually call the renter or the housing provider and let them know, notify them that your housing provider wants to mediate a situation. And then we sign up for the mediation dates, and parties decide whether they wanted to do an online mediation or an in-person mediation. And we can also do a joint or a caucus mediation. Joint just means parties will be in one room when we're having mediation, or a caucus means you could be in separate rooms. And sometimes separate rooms work really well. That way, especially if it's very heated, sometimes it's easier to just be separated, but it's up to the parties how they want to do it. It takes about four hours. And so anytime between that, we are talking about the facts, we're talking about what happened, we're talking, and then we talk about ideas on how we want to resolve this dispute. It says 4 hours, but the ordinance says that we can take as long as we want. We can reschedule it for another time until the party says we've exhausted all our efforts and we're done with mediation, or we have a resolution. Congratulations. So once there's a resolution, once they have the terms are, they have terms that they have agreed upon, memorandum of understanding that memorializes all the things that they've agreed upon will be written by the mediator or an attorney. Your attorneys are welcome to attend as well, and they will draft that, and then the parties will sign it, and then that would be it. And then if there is not any movement, there's no progress, the mediator will make the call and say, it's probably not going to happen. We're going to conclude mediation. Next slide, please. Okay, so what types of disputes can be mediated? Let me just go back and say mediation has been around since the 70s in California. Started off in LA. And it's been something attorneys have been doing for years, but recently it's just been coming to the general public, and it's been working. It works so well that it's starting to become, in the legal world at least, the way to resolve disputes instead of going to trial. It's just becoming just, let's just go mediation, and then we'll resolve it that way. Especially now with the cost of litigation is increasing like everything else. And of course, the courts are so bombarded with the cases that they're really pushing for mediation. And it's not just because of those reasons, but because it's just so successful. So things that you could mediate are rent increases, late or non-payment of rent, security deposit. We see this a lot. Maintenance issues, habitability issues, property damages, evictions, rule or lease agreement violations. Just a quick story. Recently, we had a case that required, that had a habitability issue. And there was some repairs that needed to be done. It had been lingering for years, and it hadn't been resolved. It hadn't been addressed. So finally, they had this. They asked for mediation, and then instead of going to courts and having all the attorneys, fighting with each other, the parties decided, okay, let's start working on how we can get this resolved for via repairs. Let's start the repairs. Let's get it done. Let's agree on this is going to be our course of action, and then we'll go from there. So these parties that I worked with, they're currently in the process of doing the repairs, and everybody's agreeable to that. And also they've agreed that if it doesn't work out, if it's just taking too long to do the repairs, we have another course of action that we're going to take. So it's so flexible that everybody could just, work together and coming up with what's our next move? What are we going to do next? Instead of saying, you know what, I want to go to my lawyer, I'm going to sue. So it's just a beautiful thing. Next slide. When is mediation appropriate? It's appropriate if you don't want to go through the legal route, the litigation route. You don't want to spend tons of money on attorney's fees or and court fees. You don't want to prolong this problem. You don't want to have to go through eviction court. You don't want to ruin the relationship between you and your renter. Sometimes your lease agreement is still, they still have their lease that is ongoing, so they're not leaving anywhere anytime soon. You don't want that awkwardness to be lingering or that tension to be lingering, and maybe you don't want the other tenants to know about all this and make it, blow it up out of proportion. So this is a great time to do it because mediation will allow the doors of communication to be opened. And if there's any misunderstanding or, people just need to let out what they need to say, they need to be heard, mediation is where it happens. Next slide, please. Okay. So cost benefit analysis, let's just look at it from a rational point of view. And a practical point of view. So between litigation and mediation, let's do the comparison. If you go to litigation means filing a case in court. It can take about 2 to 12 months. Unlawful detainer court, which is eviction court, is fast-tracked, but sometimes if the tenant or the renter wants to take this to trial or they want to fight it, it can take up to 12 plus months, let alone if they want to appeal the case, that's going to add more days or months to the conflict. So in mediation, it typically resolves about 2 to 4 weeks at the most. I mean, sometimes it will resolve within 1 week, And that's including, you know, all the going back and forth from intake to the day that we have mediation. So it's super fast tracked. Cost, obviously, that's a big concern, right? Minimum, you would pay $5,000 to up to $25,000 if you go to trial, maybe even more, to pay for attorney's fees, go through the whole deposition and discovery phase, and maybe even if you have to hire an expert witness, it just keeps stacking up. And then in mediation, it's low cost, it's minimal administrative fees, if any. Of course, if you're in unincorporated Alameda, it's free. So it's a no-brainer. Formality, highly formal in courts. There's tons of rules, evidence rules that take place. And that's what usually prolongs everything. In mediation, it's informal, it's flexible, and it's collaborative. If you want to share your documents with each other so that you could be on the same page as to what you guys are arguing about, you are welcome to exchange documents and for the purposes of resolving the dispute. And there's no rules about it, except if you just need to decide whether this is going to help you basically explain to the other side that this is the reason why I had to do this, Control over the outcome in litigation, judges just make the decision. You don't have say as to how you want it to end. They decide who's a winner, who's a loser, and then that's it. There's a judgment. Parties craft their own ideas, their own agreements in mediation. Mediation, you can be as creative as you want, as long as both parties are okay with it, in coming up with how you want to, what kind of terms you want to have to resolve it. Confidentiality, the court records are not necessarily confidential. It shows, obviously it'll show parties who have filed a case against you or vice versa. So it's pretty public. Mediation is private and confidential. That's huge. The state of California wants mediations to be confidential so that all parties can feel free to speak their minds without fear that it's going to be used against them in court. So everything from our emails, text messages, phone calls, it's going to remain confidential in the mediation process. The relationship impact, again, if your renter is still going to be living on your property for a while, then you don't want to have that tension, right? You want to be able to have the doors of communication open so that you can feel free to text each other or call each other or speak to each other whenever something comes up without any of that, animosity or tension. There's no faster way to ruin a relationship than taking somebody to court. Everybody knows that. So that's something to think about. Enforceability, which means if there is a judgment, if the judge just makes a decision in court, then it's enforceable. It's whatever, and it's binding. So whatever the judge says is what's going to happen. In mediation, contracts or agreements that you have, the settlement agreements, are also enforceable as long as both parties sign that agreement. Sometimes, very, very rarely, a party will say, okay, I'm going to agree to this settlement agreement, but then later on they decide I can't follow through. So there's a breach of a contract. If that happens, then you simply just take your case to court under breach of contract, and then you can litigate it from there. Risk exposure. This is also big. If you're in litigation, there's a risk for a losing party to have to pay for the other side's attorney's fees. There can be a risk of getting fines and penalties, of paying for damages, which could, if a jury decides that they want to award the tenant or the renter an exorbitant amount of money, I mean, there's nothing else you can do. You gotta appeal it maybe, but you risk yourself, you put your risk into doing that. I have another story. So there was this case where a housing provider wanted to sell their property. So the renter was given notice, and then housing provider gave a portion of the security deposit back, but the renter wanted to dispute that. So the renter had already moved out. Housing provider already listed the property on the market. And so we thought about, oh my goodness, what if the renter decides to put a lis pendens on your property? And then that will halt or disrupt your ability to sell your property. So instead of, those are things that came up. So those are part of the risk. So they decided, let's mediate this. Let's figure out a way to compromise with each other and to come up with an agreement. It took about maybe a week to 2 weeks to do this, and everybody had ideas, and it eventually became a settlement agreement, and everybody now is satisfied and moved on, and they're back to doing what they needed, what they need to do. So that's one of the greatest benefits, and the mediator will usually bring that up to you, like talk about risk exposures. If you ask them what they think, they will really give you their thoughts on that. But there's lots of things to think about before going to court. Emotional toll, of course, litigation is stressful. It's protracted. It takes a long time sometimes. And sometimes in discovery, they would, when you're doing depositions, all sorts of questions need to be asked, and so many private things need to be, brought up. And sometimes that itself just causes so much stress. In mediation, the impact is a lot less. It's a lot more gentle, but yet it's still very effective. Next slide, please. Does anybody have any questions? That was a lot of information. No questions so far? Please feel free to put that in the chat too. I know it's a lot, but I want you to just kind of take it in a little bit. And again, for those that are coming in a little late, please, if something comes up later on, if you have a question later, feel free to email myself or ACHPRC, and they'll be more than happy to find the answers to your questions. Okay, so let's go to Alameda County Ordinance, Chapter 3.68. This pertains to the unincorporated Alameda County. So for housing providers, they are required to provide a written notice to renters starting December 14, 2024. Some of you may not have done this yet, so this is a great time to do it. It says when entering, you're supposed to give this notice when entering or renewing a lease, when giving a rent increase notice, when notified of untenable living conditions or habitability conditions. Next slide, please. By the way, we have a notice available. It's a template notice. If you are all interested in getting that notice, please email us again and we'll send that out to you. Next slide. Oh, okay. So, sorry. So number 2, your housing providers are required to participate in mediation. This is huge because if you give these rent increase notices, the renter can say, hey, I want to dispute this. I'm calling, I want to activate mediation. So they will come to us and they will say, I'm disputing this. And so the mediator at Rental Mediation Services will contact the housing provider or vice versa and let them know we need to mediate this. When you get this notice to mediate, you are required to show up in mediation. You're required to show up and participate in good faith, which means, you need to be there and really wholeheartedly want to try to resolve it. You're required to share relevant information. For example, we had a case where the rental or the renter needed records of all the times that they paid their rent. So if they ask for that, you're required to share so that we can resolve the dispute. And then you cannot, if you decide you just don't want to attend mediation, you can't increase your rent. So the rent increase cannot take effect. It's very explicit in the code or the ordinance. So that's huge, right? We had cases where a housing provider just ignored the notice, and so he had just sent that notice of rent increase, and it's supposed to start in a month or two. And as long as they're not attending mediation or participating in mediation, they cannot increase that rent. So the renter will not pay the rent increase. Okay. Go back to, so three are, okay, again, renters cannot increase the rent. It will not take effect until mediation ends. Okay, next slide, please. Okay, when can housing providers request mediation? Yes. So it's not just the renters who can do this. You all can do it. And you should do it 90 calendar days from the time of the ordinance enactment, which was December 14th. So anytime now you can. Within 45 calendar days of receiving a written notice from a tenant regarding habitable issues such as a roof leaking, electricity is not working, maybe the heater's not working, those types of things. So you could also do a request for mediation. Within 21 calendar days of serving a notice of rent increase that raises the rent to more than 5% above the base rent, you can also ask for mediation. If there's within that 12 months, you ask for another rent increase, you can also ask for a mediation to kind of explain why you're asking for another mediation or another rent increase. Within 14 calendar days of learning facts that give rise to any other rental housing dispute. Say they violated a noise rule that you have, ask for mediation. Next slide, please. Renters can ask for mediation as well. And they typically will ask when the rent increases more than 5%, and if they have within 21 days from the time that they were given that rent increase notice. If there was already a rent increase within the last 12 months, they have 21 days to ask for mediation. Conditions are inhabitable within 45 days of knowing that it's inhabitable or there's an issue, they need to let us know. Sometimes because the issue is continuing, that 45 days pretty much drags on. They continue to have the ability to ask for mediation. Other serious issues arise within 14 days. Of knowing it, they should ask for mediation. Renters must also participate in good faith, or their case may be closed. Next slide, please. Any questions so far?
I have a question, Mae.
Sure.
So it says here when rent goes up more than 5% within 21 days, the tenant or renter can request mediation. What if it doesn't go up above 5%? Let's say there's like a 3%. Can the renter still request mediation to hold off the rental increase?
Well, no, it's pretty explicit in the ordinance. It says it's more than 5%, so probably not.
Okay.
Yeah. Okay, so you're welcome. So some just a gentle reminder, according to Chapter 3.68, there are civil penalties and injunctions are possible if housing providers break the law, and retaliation is illegal if your renter asks for mediation. I also had another case where the renter did ask for mediation, or they had taken they made a complaint to code enforcement, and then the renter or housing provider decided to increase rent. And then so now we're in mediation for that issue. So just please keep in mind that retaliation is illegal. Next slide. Okay, so some tips outside of mediation that you could incorporate with your team. If you have a property manager, you can maybe share this with them. So how to resolve disputes with renters. Respond timely. Don't ignore it. That's the last thing you want to do. Don't ignore the issues that they're bringing to you. Schedule a time to meet. This is huge as a mediator, as conflict resolution specialist. We always say when a renter comes to you, either through an email or in person, and they're really heated and they really need something fixed ASAP, and they're just in this, heated state, I suggest that you ask them to say, hey, I hear you. I really want to get to the bottom of this with you. Let's schedule a time to meet. And this is huge only from a dispute resolution perspective, because it gives everybody time to cool down. I see a lot of issues that escalate unnecessarily because the first reaction is defensiveness, right? We want to defend ourselves, obviously, when somebody's coming to us hot and heavy. So to prevent this from happening, schedule a time to meet when everybody's, has time to kind of process what happened. Schedule time when everybody has time to sit down and chat, or even just be on the phone. Believe me, it works magic. It works wonders. Listen with an open mind. First thing we want to do is just defend ourselves and say, okay, but this, but I know, but this, it's your fault, So that really puts roadblocks in our communications when we want to just blame each other. So listen with an open mind, hear them out, work together if possible to come up with a solution. Then seek legal advice if you feel like you're not sure if this is something that's even, that is even your responsibility to handle. And then, of course, ask for mediation. What you don't want to do is ignore the complaint. I've seen many, many cases time and time again where disputants or housing providers will ignore a situation until it just prolongs. I have one that went on for 10 years and now we're in mediation, and it's just pretty much at the point where if they go to court, it's not going to be good for the housing provider. Don't shut down communications by responding defensively or angry in an angry manner. That's the last thing you want to do. Okay. Any questions about that? No? Okay. So basically, these are the cities that we serve for free. If you don't live within these cities, don't worry. You could call other mediators. CCDS provides it for a really low cost. I'm sure ACHPRC also has other resources that provide low cost mediation. But these are the services these are the areas that we provide free mediations to. So with that, that is pretty much all I have to offer today. Again, if you need that notice for a renter that you need to give to your renter, it's a template that we have available. You can have your attorneys take a look at it before you send it out to your renter. But it is required under ordinance chapter 3.68. We have that available, and we have other flyers available to let you know what your responsibilities are.
Thank you, May. And that information is also going to be posted up on the ACHPRC.org website. It will take a little while to get us up there, but our next release cycle is probably about in a week from now. So it should be up within the next week or so. All right. Thank you so much, May. That was a lot of great information. We would like to open it up now to the floor. If anyone here has a question to ask, please feel free to unmute yourself and ask your question. Any questions from the audience? Let's see here.
I think I have one.
Yeah, please.
I'm not currently in a dispute with my tenant or anything, but I'm just wondering when is the mediation process needed? Is it because, in other words, when is it triggered? Do I have to have my tenant has to sign the agreement first?
Yes.
So that's required. Okay.
So when do you have to give them the notice of renter rights?
Well, in other words, do I for 3 years and everything's going great? But is so just prospectively, let's say something didn't go right, would I have to have already had her sign the agreement to mediate contract, or is it are we covered already because we're unincorporated Alameda County?
Okay, that's a good question. So it says that you should provide written notice to tenants by December 14, 2024.
Of their
Yes.
So that's the first thing that needs to happen,
Yes. Did they come in before December 14?
Yes, well before. Yeah.
Yeah, it's pretty explicit. It says you must give tenants a notice of tenant rights.
Okay, so I had I don't know how I would have learned of that, but I now know.
Yeah.
So give notice of that right, and then we're both covered, right?
Yeah.
That in unincorporated Alameda County.
Right. And then, of course, if you're going to renew the lease or you're getting new tenants, rent increase, or if they have issues with untenable living conditions. Of course, again, if you have issues with them kind of violating the lease agreement in any way or any rules that you put in place, you're also free to let them know about that.
Okay, there's absolutely no issue, so I don't want to stir the pot, but I also am, aware that at any given time something could happen, or another tenant, in the future. So I'm just trying to prepare myself.
Yes, very, very good idea.
Give my tenant notification, and then that's all I need to do at this point, because I'm not interested in being in mediation because there's no issue.
Right. Yeah, that's the first step, is just to notify them.
Okay, thank you.
You're welcome.
And May, we do have a question from the audience from Ancheta. They would like to know, just to clarify, is this notice required for all of Alameda County or just unincorporated areas?
Just unincorporated areas, yes.
Okay. And I believe if your property is outside of the unincorporated areas, you should definitely check with your local city and their ordinances as well. A follow-up question, and if the tenant goes into a month-to-month lease, do we still need to provide the notice as well?
Yes. This pretty much covers everybody, all the housing providers. There are a few exceptions, but it's very, very small. So we just say everybody should just do it.
Great.
Sorry, is one of those exceptions possibly an ADU?
Yes, that's you should give that. Oh, the month to month is another. I have to circle back with you on the month to month there, because that might be an exception. So again, if I could do the research on that and get back to you. Who asked the question again?
That was from Ancheta.
Okay, yeah, Ancheta, I will get back to you on that if you want to email me. your question, and then I will give you a more accurate information or answer.
Sorry, May, this is Alan again.
Yes, hi, Alan.
Regarding the ADU question, did you are you saying so? This covers ADUs in unincorporated Alameda County?
Yes.
Okay, thank you.
You're welcome.
And May, could you tell us like what are the most common types of disputes that you've helped resolve between rental providers and renters?
Sure. I mean, I have the very more common ones, which are pretty much what is that called when they need the? I'm sorry, I'm blanking. I got distracted, but yeah, it's the what's that called? Sorry. When they ask for their security deposit back, that's usually what's common. So security deposits, usually they'll, you know, you're supposed to take a picture of your place first, and then right before you go do the walkthrough, take a picture, and then take a picture after the walkthrough. Sometimes, well, a lot of times the renters will dispute this. And like I said earlier, we just had a mediation where the renter was disputing, and they had already moved out, and the property's been put on market. But they said, no, I feel like I need to get some of my money back. And so we had to go back and forth and, you know, dig up a little bit of the records to show that, you know, there was no reason why they should have charged me for painting the walls or whatever. So we went back and forth a little bit, but eventually it was resolved. But these are the types of things that a lot of people do come for mediation for. And then we also have the extreme stuff too. But those are very rare.
A quick question.
Sure, I'm not.
Yes.
Yeah. So you were talking about the notice. I joined a little late, so I don't know what notice are you talking about, because my property is in unincorporated Alameda County.
Oh, okay. Great question. So in the beginning, Rental Mediation Services sent out some flyers to housing providers that says that starting December 14, 2024, you have to provide a notice to your renter. And we can send you this flyer as well. It shows what you're supposed to, when you're supposed to give it, and what it's supposed to say on it. We also have that letter that you can send out as a template letter, but that won't be available for about another week or so. But yeah, it provides all the things that the housing provider needs to do, and what if you live in Alameda unincorporated.
Okay.
Yeah, it's one of the things that you have to provide to your renter.
Okay, thank you.
Yeah. So real quick, it just goes by, it just says you have to provide them notice about this, that they're entitled to mediation. And you're supposed to give it when they're entering or renewing a lease, when giving a rent increase notice, and when you're notified of habitability issues or untenable living conditions. Yeah. So I'll give you the flyer if you want to email us and let us know what send us your email address, and then we can.
Yeah, just can you send it to my email address? I don't know. I think you already have, but I'll ping you. Amal
Juan,
Mohammed.
can you show them my email address as well? Here it is, right here.
There you go.
Yeah, send that out, all your questions, and then we can send you this notice. Of course, this is just this is a template, and we'll have a disclosure that says ask your attorney to review it, make sure it meets the requirements.
So another follow-up question. So is this mediation the same as the mandatory settlement conference?
Oh,
Or
okay.
that's before that?
Yeah, mandatory settlement conference happens when you're already filed a case in court.
Okay.
And usually in Hayward, Hayward Court, which is UD court, unlawful detainer court or eviction court, they will, if you file a case, they will have a day on Wednesdays usually where they have a mandatory settlement conference. And this is when they're basically telling you everybody needs to try to mediate. They have attorneys there that represent both housing providers and renters, and they could give free or low cost legal advice so that you can try to settle the dispute. If it doesn't get settled, you have to go back to court and let the judge know, and then they'll set it for trial.
Is there a way to skip that if I don't want to do it?
No, because Wednesday is 9 to 5. Basically, they're opening 9 to 4. Actually, they open the courts for you all to make that effort to settle. They will
Yeah,
let you
because
sit there.
if the renter actually is someone who just wants to use the system, started complaining about issues, and landlord responded to everything, stopped complaining and stopped paying.
Mm.
And they're just sitting there using the system, knowing that they cannot leave unless you get a court order. It's a scammer, basically.
Yeah.
And so is there a way to skip not going because they just don't want, they want to stay until November for free? That's what they said they wanted to do.
Yeah. Sometimes that happens. And they are still, everybody's still required to try mediation. Sometimes it doesn't settle on that day. And then people just say, we're done, try mediate. You just need to let the courts know what happened, and then they will set it for trial. But usually that's the next step is trial date.
Okay.
Yeah.
All right.
But wouldn't it boost their case, May, if they attempted mediation? So if a male initiated a mediation service and the tenant or renter doesn't show up or doesn't participate, doesn't it help boost your case?
If you show up for the mandatory settlement conference?
No. If they start off with mediation or attempt to start mediation.
Oh, yes, absolutely. Well, what do you mean by booster case?
Booster case as it will help the housing provider, show the courts that they tried mediation prior to going to court.
Sometimes it helps. It just the judges are usually looking to see if you settled it. And of course, if they know that you're really trying and you did early mediation, that helps a little bit. But for the most part, once you're in court, they're just looking at the law and everything and going through that process. But yeah, there was an instance where we had a mediation. It was settled. The party breached the agreement, but what they both agreed on that agreement was if one of them breached the agreement, in other words, they don't follow through with what they agreed upon, that they will allow the courts to decide that it's going to be automatically entered as a judgment. So they will skip the whole litigation part. They don't have to go through the whole trial part because they both agreed that the judge will say, okay, you didn't follow through with your payment plan. So therefore, you both agreed that if that happens, that it's going to be entered, the courts can enter that as a judgment. So sometimes the courts will just say, okay, now this is a judgment. Now you owe, it's going to be on the record that you owe your housing provider this much money. Sometimes parties will agree to something, to terms like that.
Mm.
Yeah.
Okay.
Yeah.
That's a good question.
Thank you.
Thanks.
Any other questions from the audience? I got one last question. If we do start mediation, how should we prepare before the mediation begins? What things should we come in with?
Okay, another good question. Yeah, so part of the mediation process is usually what the mediator will do once we have a date scheduled is they will send an email to both parties, sending them all the things that they need to do to prepare for mediation. For example, send us a brief or a summary of what happened and when did this happen and how you want to see this thing resolved. Sometimes we encourage parties to exchange briefs or exchange the summaries. But we'll remind you that if there's sensitive information you don't want to share quite yet, you could, leave that out of your brief. So we'll give you guidance on how to prepare to come to mediation prepared. Oh, and we also will ask you to bring your lease agreement. If you have any records of, saying that they were going to pay rent at the certain time, but they didn't, all the communications that's going to help kind of refresh everybody's memory. We'll let you know what to bring.
So it makes me think that maybe, having an email communication log is a lot easier to document than, let's say, we had a phone conversation, but there's no record of it other than a phone call. You don't know what's discussed. So I think would email be a great way to, communicate? That way you have something to bring to mediation.
Yeah, absolutely. Always, record your conversations. When I say record, keep record of written communications. Sometimes phone calls are a little harder to capture what was agreed on or what you guys spoke about. So that's a little harder to bring to mediation, kind of refresh people's memories. Text messages, you can also bring those. And again, it's confidential, so don't feel like this is going to use against you in court. The judge will not approve of this as a evidence if it was brought up in court. So that's the whole reason why we have confidentiality agreements, so that everybody could feel free to just, let's talk about what we need to talk about and let's look at the records so that we can resolve this.
All right, thank you so much, Mae. Any other questions for the audience? No other questions? Well, Mae, I think that is it. Thank you so much for joining us today. I hope that everyone gained a lot of information, a lot of knowledge in regards to the mediation process. And hopefully, everyone lucks out and we don't need mediation, but wow, it's really helpful to know it's there. And for being practically free service for unincorporated areas of Alameda County, I think it's a huge benefit, and it shows that the county is really supporting unincorporated areas.
Yes, it's free. It's wonderful. Mediation, private, John can attest to this. Private mediators will charge thousands and thousands of dollars, so you guys are in luck. Take advantage.
Great. Thank you again so much, Mae. Last call for questions. If there are no questions, what we'll do here is that in a few days, we will be posting this to the ACHPRC website. So if anyone would like to review this, they can. And if anyone has any questions, please reach out to Mae or reach out to the ACHPRC team. Thank you so much for joining, everybody, and have a wonderful Wednesday. Thank you.
Thank you. Bye.